Reference number NIC 2021.
Yes.
Falusi Ido Koyi Club 1938.
Are the parties present?
Parties are absent, my lord.
Okay. Appearances, please.
May the call be please.
Yes.
MC Mofuru.
MC Mofuru.
My lord, my appearance is for the claimant.
Defendant.
For the claimant. Very well.
Yes, my lord.
Yes, what is our business of the day today?
It's for motion, my lord.
Yes,
and
I know.
the lawyer to the defendant are also here.
He's also present.
Yes, my lord.
Okay.
Imitokwe.
All right. Appearances for the defendants.
Imitokwe, you are muted.
For the defendants.
She's muted.
Mr. Wokoro.
My lord.
Okay,
my lord.
but it's present. Something more.
She's muted now.
Who?
May it please the court?
Yes.
Yes, I am Temitope Orebi.
Okay.
My humble appearance. Yes, my lord. My humble appearance is for the defendants, respondents, and those suits, my lord.
Very well.
Yes, my
lord. Yes. So the matter was adjourned for report of settlements or hearing of the application. So which one are we taking now? Yes.
Yeah, we have an application, my lord, to amend our processes, my lord.
So report of settlement has broken down.
Yeah, my lord, if I may, my lord, we had a meeting. Yes, my lord, we had a meeting with the claimant applicant where we talked about the issue. Yes, my lord, where we talked about the issues between the parties. And
very well.
Yes, and we had settled a great deal of the dispute that was between the parties, except for 3 gray areas, my lord.
Okay.
Yes, my lord. The areas are payee under deductions, one of the areas. The second one was tax. Yes, tax on terminal benefits. And the third one, my lord, being exit benefits. These were the only 3 gray areas left. And we are surprised to be served with the claimant applicant's motion to amend the whole processes, my lord. I mean, we had already gone into negotiation. We had settled a lot of issues, except for these 3 gray areas. Only for us to be served with the application to amend the whole process. And looking at the amended process, we saw that most of the facts given were overreaching on us. These were admissions we made during arbitration. These were information that we are giving, and the claimant applicant used those information to amend the process. We called, my lord, that those the amended process, the information is overreaching on us, my lord. And for that, we will be opposing to the moving of this. Yes, my lord.
Okay. Okay, let me hear you, Mr. Mokuru. You heard that.
My lord.
Yes.
Yes, my lord. Mr. Mutagwe is actually appearing in this matter for the very first time, my lord. Yes, a colleague of ours, Nancy, have always appeared on this matter. So she knows how far we've gone on this matter. And even personally, on personal basis, I know how far I've even spoken to her and even her boss as with regards to our interest to settle this matter. My lord, the application we've had is to amend our resulting processes. whether it's a motion or notice. Of course, if they intended to oppose the application, they know better of what to do, my lord. So I don't think it's right for them to be opposed. If they have any issue, they can file a response. But as to applications, my lord, I don't think they have a right to oppose having filed a motion on notice if they've not responded. And there are no positions in our amendment. If there are anything they want to react, they can file a response to it, or if a consequential amendment, which the law allows them to do.
Okay. The only problem is that from what she's saying, she sounds as if they did not anticipate this at all.
Exactly, my lord.
Yes, counsel, but you were served with this motion. That's why you're in court now.
We served only last week, my lord, on the 19th.
19th, okay. Today is 28.
Yes, my lord.
So, if you didn't deem it necessary to respond, could it be that you agree with them?
No, my lord. We actually want to we are actually planning to file our counter. We have already prepared it. We are at the verge of filing and all, but we have not yet done that. So we will respond to them, bringing up these 3 areas where we have not settled, and not the whole processes, my lord.
I see. The reason why I made this a Zoom hearing was that I was hoping against hope that today would mark the end of all these matters.
Yes, ma'am. That's the point I want to explain, my lord. Like I said, Mr. Mitope is appearing in this matter for the very first time. He doesn't know the process. Please. Can you, Mr. Mitope, even in the amended process, my lord, we admitted all the issues settled already, my lord. We admitted even to the payment made, my lord. So if you cannot say it by overreaching, my lord, we admitted even to the that they paid a particular amount of money, and them have been deducted from the total claim we are making, my lord. You cannot say we are overreaching, my lord. We deducted all they paid so far. Amount you are now claiming in the amendment. Like I said, if it was the former lawyer who would be having series of meetings with, she won't be making this position to this application. But our application is just to amend so that to bring the only thing we are claiming now is the remaining. We've subtracted what they paid us, my lord, from the total claim. She can open the process and we've subtracted all they paid us, and now the only thing we are claiming is just the remaining, my lord. The remaining from the claim. So you cannot say it's over.
And is that substantive? Is that substantial?
Yes,
is that substantial?
Yes, my lord.
No, my
lord. And my lord,
So the tune of
this
how much?
application, my lord, is ripe for hearing today. This application is ripe for hearing today. And they've not filed anything.
Remember, they have not filed a counter, and they said they will intend to file a counter. So it is right for hearing.
Okay, my lord. The amount we are claiming now, after subtracting the amount paid us, we are claiming 2.1 million 504,000. 154,155 naira, my lord. It's a substantial amount, my lord. That's what you are claiming. So far, my lord, they paid about 726,000. And my lord, is contained there in the process. And we subtracted it from the total amount we were claiming. So she cannot say we are trying to be overreaching. My lord, I personally have been calling them and updating them on everything happening on this matter. The last time the matter came up for hearing, my lord, they were not in court. And I personally called them to tell them, please, the matter be moved from that day to the last adjourned day. That was 2 days ago, my lord. And even that day, they were not in court. I personally called them to tell them, please, this matter came up today for hearing of application, but because you're not there, the matter they are just, so I don't see any way. If I was trying to advise them, I won't be giving them all this information, my lord.
I know.
Like I said, the process so far, we are admitted to everything they've done. Yes, they paid a particular amount of money, and same have been deducted from the total claim. It's a helpful application not to amend our processes. And of course, they have the right to file a constitutional amendment in defense of anything they think we've raised here.
My lord, yes, my lord, that's the position, because we actually came to the arbitration. We came with open hands. We gave information. We were at the verge of settling, except for the 3 areas that I mentioned earlier, my lord, that we were not able to come to a truce in. And we were not expecting to be served with a motion to amend all of the processes of the claimant applicant. But as they've done this, my lord, we will need to file our counter affidavits to that. We'll be praying the court for a short day to enable us to do this, because we were not expecting to be served with a motion to amend. We were thinking they were already at the verge of settling the whole issues between the parties, my lord.
My lord,
Well,
I'll be vehemently opposed to the application, my lord. My lord, like she directly admitted that this application was served on them, my lord, on the 19th. On the 19th, and my lord, the last adjourned day this application was supposed to be heard, my lord, was on the 20th, on the 21st, my lord.
It was not ripe at that time.
Now, hold on, I'm just in the court. Now, she admitted that they were served on the 19th, my lord. And then the matter came up on the 21st for hearing this application. And my lord, that day, the court did not sit, my lord. And now, the matter was then adjourned to 1 week after, which is on the 27th.
That was yesterday.
Yes,
and
my
we
lord.
could not take it.
Yes, my lord. And my lord, like I said earlier, for each of those days, I've always called them and reminded them that this matter is coming up for the hearing of our application. My lord, what we are fighting, my lord, is so that if we make this amendment, my lord, they will have all this period for this vacation to file consequential amendments, and then we will come back by maybe November. Then we are coming to trial, my lord. That's what we are trying to do. Instead of now waiting till yes.
Well, as it is now, counsel, I feel your pains, but you know that anything we're doing at all is worth doing well. And like I told you, I was so hopeful that today we will hear your application, and from there we take it from there. But now that the other side is represented, and the counsel is telling the court in the open court that they intend to, file a counter to what we have filed before the court. There's nothing else we can do than to allow them to do that, even though we are not happy that they have not filed it all the time.
Apologize, my lord.
Yes, we are not happy about that, but we must necessarily allow them to file it. But we must necessarily pat them on the back, because Mr. Nwokuru has been very diligent, as you people have also been diligent, but he has been very, very diligent. So, Mr. Nwokuru, we must allow them to file whatever they want to file, so that we give it an early date. Once we come back, we hear the motion, and I promise you that we'll give it accelerated hearing, so that by that November we are talking about, November, December, we know where we are.
Very well, my lord.
Very well, my lord. I'm not. This is not a way of trying to oppose the court, my lord. But I just want to point to one particular direction, which is the main thing for them wanting to file a counter, which is the fact that some settlements have been made, my lord. Like I mentioned earlier, my lord. I'm not taking that. If my lord is mandate to grant them the agreement to file their response, I'm not opposed to that. But my lord, the major reason they want to file the counter is on the fact that I said we've already admitted in our amendment.
Of course, they should know that. No,
yes,
they
like
should
I
know
said,
that.
yes, my lord.
They should know that. You give them that credit. They should know that.
We noted that, my lord. We noted that. We're just saying the gray areas, and which I itemized, my lord. It's the payee under deduction, tax on terminal benefit, and the exit benefit. Those are the areas, my lord, where we are having issues. And when we come to court, we hope that the court can actually see these gray areas for us. That's when we admit the fact that yes, they know that we've made some payments, but we have not agreed in these areas, and that is what brought their processes to end with information that we give during arbitration, my lord.
My lord, those payee under deduction you're mentioning is not contained in anywhere in our claim. Those are for that came in during arbitration, which we didn't mention in our amendment, my lord.
Okay, when they file, it will be resolved. We will all resolve it.
Very well, my lord.
Yes.
However, my lord, if my lord is managed to grant him adjournment, my lord should be on 10.
Yeah, that's why I said we'll pat you a little bit at the back. We
Yes,
will
my lord,
my lord will be
at the back. Well, Patience, my registrar, please give me a convenient date. If possible, let us take one date first. But I promise that we're going to hear this expeditiously. We're going to hear this.
Very well, my lord.
Ensure that this matter doesn't go to 2023, 2024, etc.
We do not hope that for that, my lord.
Okay, all right. So let's take a date.
My lord will be asking for 100,000 naira, of course, man.
Only.
Only 100,000 naira. We are fresh, my lord. I call his boss. I will talk like I don't know why she's bringing the fire today, my lord.
We have shown good faith in this matter.
Your learned friends. How much are you considering? How much are you considering?
Well, we're not considering to court. Being well that we have actually come together with the claimant applicants. We've tried to settle this matter. We are very sorry that we are not able to file our counter. We are just taken unawares by the fact that they served us a motion to amend. We were not expecting it, my lord. And that's the reason. Be that as it may, we'll file our counter, but we are opposing vehemently, my lord, to their application for cost.
But remember that you were served on the 19th. And now we are now giving you a chance even to to bring a counter. Think about it. Think about it.
It's even a privilege, my lord. As of today, the motion is not for hearing, my lord. It's even a privilege that they're asking for.
The reason why we have not been able to file is that we needed to go back to the defendant in this suit and get one or two information because we were surprised about the amended motion. But my lord,
but that is the case for the defendant. It is not. Is you were trying to resolve your own cases. That is your whatever is stopping you from that. You were trying to resolve it by yourself. Now it has affected the case adversely. So that's why we are patting them at the back. So it will be better you tell me what to consider. The court will take its own. Okay.
Okay, that will consider for 5,000 for not being able to file before. My lord will be considering to the cost of 5,000 naira for not being able to file before today. We apologize. It's not our practice. We really apologize for that.
Is it Folashade? Tell me talk way.
My lord.
Your learned friend said 100,000 and you're saying 500,000.
5,000.
I said 5,000, my lord.
5,000. No, I said 5,000.
My lord, even area court, even if we were an area court, my lord, 5,000. Even if we were an area court, my lord.
Okay, Patience, give me a date, please. Confirm from both of them. Let us know when it is All right, for you. What date?
October 17, my lord.
Okay. How do you stand on October 17, both of you, please?
My lord, it's convenient.
Okay. Temitope. How about you? What's her name? Temitope, Esquire. 17th October, is it convenient? Is she up? Oh, this one is for the Clement applicant.
I think somebody joined and raising his hand.
Okay, I shall, since we can't hear from her, the Clement applicant, what? What do you mean interested? I wanted to say 50. Let me be 30. Then the adjournment in this. And the cost awarded. I thought it would be too much. All the different cases is 289, 290, and 291. Are they only four? So at this stage, this matter is adjourned to the 17th day of October 2022 for hearing of the applications before the court. Meanwhile, the claimant applicant is awarded a cost of 30,000 naira only. Now, the adjournment in this case and the costs awarded affects all the sister cases. That is 289, 290, and 291, 2021, respectively.
As the court pleases.
Yes.
Next.
Court pleases. My lord, I didn't hear the cost that I awarded.
Yes, you said?
I didn't hear the cost that was awarded.
The award, I awarded a whooping sum of 30,000 naira only per case, per each of the matters.
Okay. Okay.
And whatever applies here applies to the sister cases. Okay, now. Thank you.
My lord.
Very well. Patience.
Yes, my lord.
Let's have the second case.
Okay, my lord.
Yes. Yes.
Case number. NITM/LA/123N/2019/2020 before Mr. Martin Chijoke Agwede and Hanover Trust Limited. 2. Hanover Terminal Limited. 3. Mr. Steve Johnson Obu. Parties are absent, my lord.
Very well. Appearances.
May please, Honorable Court.
Yes.
V.N. Olisa.
Yes.
V.N. Olisa.
Very well.
My humble appearance is for judgment creditor applicant.
For judgment creditor applicants.
Yes,
very well.
my lord.
So this is a motion expert.
Yes, my lord.
Okay. Very well.
The motion is dated first day of April.
Yes.
2022.
Yes.
And it's
when was it filed?
Section 83.
When was it filed?
First day of April 2022.
Okay, it was filed on the same day.
First day of April 2022.
Okay. Yes.
Yes, my lord.
Very well. Yes.
The motion was proportion to section. The motion is proportion to section 83.
Very well.
Of the Sheriff and Civil Process Act.
Yes. Yes, go on. Yes.
And it's praying the Honorable Court. The orders on the motion are an order that the Kanyip appear before this Honorable Court to show cause where an order should not be made against them for the payment of the amount of the judgment debtor's money with the Kanyip as we satisfy the debt due under the judgment of Honorable Justice A.O.A. Obaseki or Sayere, entered in favor of the judgment creditor applicant on 21st of June 2029 in the sum of 151,000 naira. The second prayer, my Lord, is an order 9 side, attaching any monies in the account of the judgment debtor with the Kanyip, any of their branches throughout Nigeria.
Yes.
The top prayer, my Lord, is an order compelling the judgment debtors to forthwith release the judgment creditor applicant's delivery van with registration number XY 352 EPE in the tender of the first judgment debtor, and any other order as the court may deem fit to grant in the circumstances of this matter. An affidavit in support of the application was sworn before this court on first day of April 2022 by my humble self.
Okay.
Is 13 paragraph affidavit with an exhibit. The exhibit attached, my Lord, is the judgment of this honorable court granting the claims of the judgment creditor in this suit.
Okay.
In line with the rules of this honorable court, we also filed a written address in support of the application with one sole issue for determination.
Yes.
And we only pray the honorable court to grant the application as prayed.
Yes.
You are most obliged, my Lord.
Very well.
But this is another matter.
Okay, I'm sorry. Yes, I'm very sorry, my Lord. My network was giving me issues. I didn't mean to just go out abruptly. I'm really sorry, my Lord.
Oh, very well. That's all right. Everything is all right. Don't worry.
All right. Okay. Thank you, ma'am. I'll
All
get
right.
in contact with you. Thank you.
Very well. Thank you. I don't know whether can I will accept for eventually. I enjoy my personal. Friday. Eventually, it's just it means I make it because I get now. You get some of the job Mr. Victor,
Yes, my lord.
I don't know about this. This is not just a straight application just for Ganishis to come to court to show cause. With the other
Okay, my lord.
application,
Prayer 3.
yeah, with the other release of cars and all that.
That is the order. I want to quickly withdraw it, my lord.
You want to quickly withdraw it?
Yes, through the leave of the court, I want to withdraw the order compelling the judgment debtor to release it so that it will solely be for guardianship proceedings, my lord.
Counsel applies to withdraw the prayers.
Prayer 3, my lord.
No, prayer 3.
Yes, my lord.
Yes. In that case, we can rule now. Court. But, you may relax your hand.
Excuse me.
Patience, can you start looking for a date?
Yes, my lord.
Yeah. That's not fast. It's so fast.
Yes. Debtors.
Huh?
3.
Okay. Ah, they will bring. Are we here?
Yes, my
Mr.
Yes,
lord.
my lord.
Anita? Yes. Now, upon hearing the Learned Counsel to the judgment creditor applicant move his motion ex parte, and having gone through the affidavit in support of the same, and also the written address, also in support of the motion, the court equally had cause to reread the attached exhibits, which is the judgment of this court concerning this case. And the court is convinced that unless and until this application is granted, that it will be impossible for the judgment creditor to reap the fruit of his judgment, whereby the court hereby grants the application of the judgment creditor as prayed.
As the court pleases.
Yes. And that is to say that the garnishes in these proceedings, well known to the judgment creditors council, yes, shall appear before this court on the next adjourned date to show cause while the monies of the judgment debtors sitting in the accounts in their banks shall not be used to pay off the judgment sum by the court to the judgment debtor. And the matter is therefore
As the
adjourned
court.
to, when is it adjourned to?
20th October, my lord.
My lord, may I humbly suggest another date? 20th, I'm engaged, my lord. My lord,
Yes?
may I humbly suggest another date? On 20th, okay. On 20th is okay. Is a case at National Industrial Court. It's okay for me.
Okay. You can come and then you can come first, and if you indicate, we can take you quickly so that we discharge the garnishes. And you
As
can
a couple.
also, yes. But before I started this, I had already written that the Learned Council to the judgment creditor applies to withdraw prayer number 3 from the motion, and the application is granted. Prayer number 3 is hereby struck out. Yes. Yes. Okay. Yes. Is there any other? 20th of October.
Yes, my lord.
Patience, did you say 20th of October?
Yes, my lord.
Very well. That is when it is adjourned to.
So
we shall see on that date. Oh, very well.
Okay, my lord.
I'm most obliged, my lord.
Very well.
Have a pleasant my lord.
Thank you. In Nigeria, the word they call shall arise from wherever I'm sitting, I will arise.